Welcome. It's December 1st, 2021, the last month of 2021. We are here for our regular weekly Wednesday, 6 p.m. Pacific time educational period, talking about U.S. immigration live on YouTube, on TikTok, on Facebook, on LinkedIn, and a lot more places. Plus, you'll find the recording and clips of this on all the pages, in particular YouTube. Before we start, I want to remind everyone who's watching the live show, and for those watching recorded, to catch the live show on Wednesdays, 6 p.m. Pacific time, because we give out 3 free consultations, 15-minute video consultations for those who watch. While you participate in the raffle is, if you're watching live, you like, subscribe, and you write a comment saying consultations, and my wonderful assistant Katrina will announce a winner every 10, to me at least, behind the scenes, 10 minutes, 20 minutes, and at the 30-minute mark. So you'll be able to watch that, and be able to hook up and connect with me to get that free consultation. So definitely join it. We have a lot of happy people do that, and a lot of our regulars. Also, other than that, if you're interested in a marriage green card case, a fiancé visa, there's a lot you need to know, and the best way to get free information on that, really thorough information, is to download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com, and learn about that. Download the PDF that has all that information. You're going to get a lot of good information that's going to help you out and teach you about the process. And with that, let's get the show started. All right, as people are starting to trickle in and ask their questions, I want to thank everyone who's joining. It's a troubling kind of week. We hear about this new COVID-19, variant that emerged, calling it Omicron now. Well, the situation is, as always, everything affects U.S. immigration. So there is a travel ban announced for several countries in Africa, and it's similar to the previous travel bans, whereas if you had been to that country within the last 2 weeks, you're not allowed to enter the United States. But if you have a visa, say you're South African and you have a visa, or not even South Africa, but you've been to South Africa, you can wait outside for 2 weeks in another country that's not on a ban list for being able to return to the United States or come to the United States. But practically speaking, it's going to be hard if you're in those countries to even get a visa. There was a recent court case that said the embassies have to still issue the visa, even though you can't enter if you've recently been in those countries. But practically speaking, again, these embassies are probably going to shut down or be low staff and not even do visa interviews, so it's going to be hard to get one. And we have situations where people in the United States who need to leave, for example, they're on H-1B work visas. If they want to re-enter, they have to get a new H-1B visa. But I have a South African client who I can't recommend leaving because he won't be able to get a visa interview probably, and he'll be banned from coming in. So he's stuck here and he can't visit his family and do some stuff he needs to do in South Africa. That's the situation there. But it's unfortunate how this stuff works. Now we have our first question from Muhammad Madir. How much time does it take for USCIS to approve an I-360 religious worker at California Service Center? Well, what you should do is go to uscis.gov and follow the links to get their processing times, and they'll give you an estimate of what their processing times are. Having said that, they're completely unreliable processing times. So the true answer, the honest answer, and it will give you about a question like an I-360 for a religious worker right now, is there is no answer. So you just have to submit it and make sure it's properly done and hope for the best. But there's no real good answer to what timelines are looking like on those. So definitely there's just something you got to deal with and hope that it's sooner rather than later. Now, with regard to how long things take, is different based on the service center, and within that service center it's going to be different too, because you might get some officers who are faster and some who are slower. Now, when it comes to things like adjustment of status, if you're doing a marriage case where an interview is required, I'm getting these done really fast in Los Angeles, sometimes as quick as 3 to 6 months. But I have cases in San Francisco that are taking a year or more. So it's really inconsistent. San Jose just got really fast. They're hitting the 3 to 6 month mark recently. I had a case in, they lived in Illinois, but they had their interview in St. Louis, Missouri. And that took around like 5 or 6 months. So sometimes it's fast. It's so fast that the work permits and travel permissions don't even come. Conditional green card holder, which is expiring in February, mid-February, and divorce is in process. So that gets a really troublesome spot. When you're doing a removal of conditions, when you're in a process. So let's back up and see what removal of conditions is for those watching new. If you're getting your green card based on marriage to a U.S. citizen or green card holder, if the green card is approved within 2 years of your marriage date, they issue you a 2-year green card instead of a 10-year green card. The reason is, after 2 years when the card's about to expire, they want you to submit another application for I-751 to say that this relationship was real and prove it. Now typically people are still in a relationship and they may have children, they may have property together, there's always documentation they can submit, but sometimes they get divorced. Now you need to have all the documentation to prove your relationship, so you need to have accumulate documents to help prove it, maybe have personal statements or something like that, and you may have the interview, but if you're going to get divorced, USCIS cannot make a final determination on the case, and they can deny it if your divorce is not finalized by the time they adjudicate it. So in your scenario right now being December, and you have your green card expires in February, and your divorce not finalized, you can submit the Form I-751 as a solo single in the sense of not having your spouse sign it, but you will get a request for evidence if by the time you submit the case, your divorce not finalized, and you'll get a request for evidence saying, hey, we want the final divorce certificate before we can approve the case or move forward, and hopefully by that time you'll have it. Now, when you do what's called the case, what do they call it? It's not a waiver case. For I-751, solo, without the spouse, there is no necessarily end time to do it, but you really want to file it before the green card expires to be safe, and then just speed up that divorce and try to get it in so that when they ask for the divorce certificate, it's there. If they do an RFE, you can potentially say, listen, let me come to the interview and I'll show you the divorce certificate because it's not finalized. Here's the court order showing it's happening. But it gets really messy, and that's the times you hire an immigration attorney. The stuff I just said right now is general information. I need to know more about your specific case, a lot of different factors, but I just want to give a general overview of the troubles that happen when you are getting divorced midway when you're starting or midway in the removal of conditions I-751 process. It's not clean, so unfortunately you're gonna have to deal with some headache. Now you have follow up with the question, if I get divorced before the decision is made, is that going to affect it? Well, that depends. Are you applying for citizenship based on a 3-year green card or a 5-year green card? If it's a 3-year, yeah, it's going to be a major issue. They're going to deny the case if you're divorced. So that's as easy. So when you file for citizenship based on marriage, a 3-year marriage kind of thing, you have to stay married and not divorced until after doing your oath ceremony or interview, oath ceremony, getting the naturalization certificate, then getting divorced. If you get divorced before that, it invalidates the 3-year aspect of it and becomes a problem. Now, if you've been waiting for so long, at the end of the day, yeah, so it's going to be a mess. Hopefully, you just did 5-year and won't have that problem. Tony Mauri says, hi John, how long does it take to get a welcome letter from the National Visa Center after your I-824 is approved? Montreal Consulate, thanks as always. Oh, Tony, one of our regulars, I'm glad your I-824 was approved. How long does it take? It should take no more than 2 weeks, sometimes 2 months. But these between 2 weeks and 2 months, but it could be as fast as 2 weeks. But the I-284, let me back it up, is for when you have a case that's begun in the United States and it needs to finish overseas, to have the case transferred overseas, that you submit I-284. The problem is, even though it's approved, doesn't necessarily mean USCIS will take the necessary steps to have the case sent out, even though that's what you paid for when you submitted from I-284. So hopefully, wait 2 weeks to 2 months. If that passes, contact the National Visa Center and say, hey, what's going on? The National Visa Center has been kind of slow in responding recently. And if they respond saying we don't have the file, then you got to contact USCIS and follow up with them. You might as well do that at the beginning. Just call, email, do whatever you can to get the ball rolling. But I have seen it many times with I-24, even though approved, just gets stuck and doesn't move forward. So unfortunately, that's the scenario with that one. We have a question from Italo. My O1 visa is expiring in January 24. I'm already applying for E3. EB3, I submitted the I-140 and I-45 and EAD card. Should I renew my O1 visa or not? Well, it's up to you. That goes into case-specific advice for me to tell you whether to renew a visa or not. I don't know anything about you. If you feel like spending the money, you might as well. If you're really sure that your I-140, I-45 is going to go through, then you don't have to. But it's a good backup to have, so generally it's recommended that you continue the O1. But I can't give you an individual advice because I don't really know enough about your case. But hopefully the rest will go through. It's going to be a personal decision and money decision how much you want to spend on it, and if your sponsor is going to feel like doing all this kind of stuff, or if the sponsor is the petition agency. IO asks, hi, I'm working on OPT, but I just filed for adjustment of status. My green card holder wife, congrats. If the I-765, that's the work permit, gets approved, can I work elsewhere with the new I-765? Or wait till I-45 gets approved. So if you have an adjustment of status, green card case pending, and you file for a work permit, and the work permit's approved and you get it, you could use that work permit to work anywhere you want. when you do work anywhere you want, potentially that cancels out your OPT and your F1. But if you got a solid case, a marriage case, I don't know your individual case. We've talked before here on the show, but I haven't talked with you guys in private, and to review your case. So yeah, but if you do get the work permit, it's open-ended. You can work everywhere with the adjustment of status category C9 work permit. So that's doable. So Ikabro asks, any info on a B1, B2 visa getting revoked due to getting vaccine in the US seen as public charge? I haven't heard of that. I'm not sure if they would call that a public charge if you got the vaccine. I don't even know how they would know. Now, if you use like straight up health services, like in a hospital or something, they won't revoke it necessarily, but they can hassle you potentially. It's not an automatic revocation kind of thing. I doubt, I mean, it's up to these people. I doubt they would say you got a free vaccine, they'll hold it against you. If anything, they want to push these vaccines. So, it's not up to me, it's discretion, but I would highly doubt it, and I don't even think it would come up. So just getting a vaccine, to me, doesn't seem like something to worry about. I wouldn't worry about it, but hey, it's not up to me, but in general, I wouldn't lose any sleep over something like that. Then again, one note is I didn't know if you fill out paperwork, say you're a US citizen, or you got a bunch of other stuff. So again, I can't provide case specific or unique information to you because I haven't seen exactly what happened, but generally speaking, this is all general education over here. All right, next question from a regular IO. If the work permit comes out, says my wife is a green card holder and I'm working on OPT, will I be out of status before I-485 comes out? Yeah, I mean, once you file for adjustment of status from I-485, if you fall out of status afterwards just due to not maintaining status, like your tourist visa expires, your OPT expires, it's okay, you're out of status, but you're what's called a period of authorized stay, which means you can stay here until USCIS makes a decision. Now, if your case is denied, that's bad news. But if it's not denied and it's approved, then it doesn't matter. If you maintain your OPT and you're not out of status, but eventually OPT is going to run out, so that's going to end. So overall, if you have a case pending and it's a good case, I wouldn't really be worried about that. But I would need to just talk with you to review all the docs to be able to give more certainty about that. I'll be doing our regulars. Hi, my B2 I-94 will expire January 2022. My I-485 approved today, and I already have I-485 is pending. What do I need to do now? If you have an adjustment of status pending already, nothing. I'd be worried if you file for adjustment of status really soon. If you came on a tourist visa, that might seem suspicious that you file for adjustment of status while on a tourist visa on an I-140 in particular. Knowing that you did the perm process, all that, but sometimes people's plans change. I'd have to see the unique circumstances. But if you, as I answered in the other question, if you have an adjustment of status from I-485 pending, then it's all good if your previous I-94 expires, your status expires, because you can stay here until a decision is made on your case. Hi, do you know how long does consular processing for London embassy will take for U.S. citizen? I assume you mean U.S. citizen marriage? No, it just depends on whenever they get around to you. So U.S. Embassy in London is a really busy one. They're super backed up because of what happened during the coronavirus. It just depends on whenever they get around to you. Expect delays in the process. And in general, there's no answer a person can give. Like, and then I could say 6 months, 3 months, but it could be either or something completely differently. So in these kind of cases, you just got to be patient, and that's about it. The whole embassy system, Department of State, is completely messed up right now. A lot of places are closed, a lot of places are backed up. When it comes to London, there are just probably tens of thousands, not 100,000 cases of people are trying to get these waivers to be able to come in, and they were missing that. So I'll be doing follows up. Thanks. I came to US in July 2021, and the I-140, I-485 were filed early November, July, August, September, October. I hope that's not too soon. Schedule A. Okay, Schedule A, that makes more sense that you didn't do the... Schedule A is an exception that they have for US of people who have certain jobs that are so needed that they don't have to go through the full employment-based green card process, and you can do it faster, and that's why you're able to file the I-140 so fast, and you may have just found a job during that time. So it's not as bad as I thought it was that we doing because you're Schedule A, but thanks for letting me know. Overall, they're probably gonna be cool with it. Now, if you filed in July 2021, you came in, so filed early November. Okay, it's gonna be another year at least until things get moving for you. They're so slow. Hopefully, it's faster, but it's taking a bit to get these done. Maycash Knuckle as what qualifies 10-year marriage green card? The first issuance of the green card, yeah. So we talked about this earlier, but if you do green card based on marriage, potentially they'll give you a 2-year green card. And to be able to get the 10-year green card, if you had a 2-year green card, you have to file an application and request it. But to prevent the 2-year green card in the first place, The day of the issuance of the green card has to be after 2 years after the marriage occurs. So if marriage occurred January 1st, 2020, the green card has to be printed out, January 2nd, 2022. And so if you're in the United States, it's going to depend on when they approve the green card mailed to you. If you're from outside the United States coming in from consular processing, the day you enter at the airport, your admission date is the date they look at. So a lot of times I've had cases where the case took 1 year and like 10 months to get approved at the embassy. I'll tell clients, hey, hold off on coming to the United States for 2 months, pass the 2-year mark, then enter the United States to avoid having to do Form I-751 removal of conditions and getting the 2-year green card. And that way just go straight for the goal and get a 10-year green card and not deal with it. So that happens as well. User 808 asks, pending asylum case, can I travel with advanced parole to another home country, to other than home country for a short trip? Well, you'll need to get a refugee travel document. If you have pending asylum case, I don't know if they're going to give it. You can always try getting advanced parole. You could apply for it, and if they want to approve it, they could approve it. There's a problem that you'll need a passport to travel, and they don't want you to use the passport for the home country. So I just wouldn't advise traveling. Now, I don't do asylum case in many years, not my specialty, but generally, if you have a pending asylum case, I know it's probably taking forever, but I wouldn't recommend flying outside the United States. You don't know what kind of situation you're going to be dealing with if you leave and come back. You might have to use your passport, which is not supposed to happen. So there's a lot of issues baked in that cake. So how many times, Karan Shah asks, how many times can you apply for a motion to reopen after first denial of application by USCIS? Well, it depends on what the motion is, what the bases are. I've read appeals cases where people did like 10 different motions to reopen and reconsider. But if it doesn't work out the first time, I mean, there's a bad chance you might file a lawsuit. It's probably better. But we have to see what the reason is that you're filing this motion. So when you say how many times you can apply, well, if you have a factual basis or legal basis of mistake, potentially you could do it again. But I don't know if you're just going to do it just to do it, then it doesn't work. So these are not the kind of questions I can just say this. It depends on the facts with much of law. Kate Perda asks, my fiance came here to USCIS as a visa holder and overstayed. Can he stay and do his process here? Oh, I don't know. I mean, if you enter lawfully, that's a good sign. If you're a U.S. citizen and you're getting married, that could help. Overstaying is no problem. But I would need to know about his background. Download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. You'll see what I'm talking about. And, if you like, just take a screenshot of where you're watching this and email it to me. You're watching on TikTok, and email it to me at info@jqqlaw.com. That's my email address, info@jqqlaw.com. And we'll schedule a private call just to get some basics of what's going on. But in your case, if you enter lawfully, no criminal history, affidavits of works, you have good bona fides and proof of relationship, potentially, yeah, they can file for a green card here once you're married. But I need to check out that stuff more in details. And God bless everybody. I really hope these delays at these embassies and the 601 waivers, all this kind of stuff, doesn't happen and it goes down and you're able to get your expedites. Praying for everybody. Until next week, God bless, be safe, and we'll talk more then. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.